Dismiss one, just need to,
Good morning. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for November 19th, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. I will make a quick notation on today's proceedings, given the cases on the docket today, as a reminder to those that are viewing via YouTube, which we do to be in compliance with the open court provisions. It is not to be recorded. The official record of this court is transcribed by our official court reporter, Ms. Erica Wright, and any requests for any information regarding today's hearing should be made through her and not recorded from the live stream on YouTube. So with that said, Mr. Pantoja, would you call, I guess, our next two cases?
yes, Judge. Cause number 2021-020-0530. Cause number 2021-020-2909. State of Texas versus Ivan Gabaldon. Announcement of counsel, please.
Your Honor, for the state, Curtis Cox and Scott Ferguson.
And I am not hearing anyone. So if you all, would you please make sure that you are on the English channel, and maybe I can hear you.
I think we make sure it's mute original audio, correct?
I do, Mr. Carmona. I don't know if everybody does that.
Where would I
And
find?
I can hear you,
English
Curtis. I
channel?
cannot hear you. So if you'll
Okay,
check
there we
your,
go. Can you hear me now?
yes, sir. Yes,
Okay,
sir.
very good.
And so if everybody will just double check that, make sure we get everybody heard. Okay, go ahead. May I have announcements, please?
Your Honor, for the state, Curtis Cox and Scott Ferguson.
Your Honor, good morning. Omar Carmona and Denise Butterworth for Ivan Gabaldon. Ready to proceed.
Okay, and Mr. Gabaldon is appearing from the jail annex remotely. He is also utilizing the assistance of a court interpreter. Ma'am, would you state your name for the record, please? Okay, thank you, Ms. Garza. And I will just ask everyone, especially reference the connection between Ms. Garza and Mr. Gabaldon, or Ms. Garza, you hearing us. If there are any issues with the audio, please let us know promptly so we can go back and clarify that. So this is a continuation, at least under the old cause number. Thank you, Ms. Garza. With some motions that we had on Tuesday. I thank Mr. Cox for providing the information that was outstanding regarding, I believe, the objections to the COVID trial process. And it looks like we were outstanding also a motion to dismiss the original cause number as it was re-indicted per the state on Wednesday. I'm looking because we're receiving simultaneous messages, Mr. Cox, that you have forwarded that to Ms. Aguirre. So I'm waiting to see if as I talk, if I get that dismissal in my email. I haven't received it yet. So in terms of the new cause number, the re-indicted cause number, I was just wanting to confirm, there it is. Confirm that Ms. Butterworth and Mr. Carmona, you all have discussed with your client now this new information on the re-indictment. And because of logistical difficulties, although it was not said, I was wanting to proceed with your client's arraignment now on the new cause number.
We have had a chance to discuss this with our client, Your Honor.
Okay, and have you had now, I think it was just forwarded to you, but have you had the opportunity, well, it's sitting there on the screen, to review the indictment?
We have, Your Honor. That is my client's true and correct name. The spelling is correct. My client waives reading and enters a plea of not guilty.
Mr. Gabaldon, are you in agreement with that?
Sí.
Okay. And so with that said, thank you, Ms. Nieto. We've provided the copies. With respect to everything that was outstanding now, I'm assuming the parties we're going forward with the motions that were pending on Tuesday now being incorporated into this case. Is that the request of the parties?
Yes, Your Honor.
Okay, and I apologize. The dismissal did not allow me to insert my electronic signatures. I just needed to print it. Okay, so I have signed the dismissal on the previous cause number. Okay, so now we have a couple of things. We have the state's objection. We also had the issue on the translation. So with respect, is there anything further on, let's start with the state's objection to the untimely filing. I believe Mr. Cox, although it may have been contingent upon a trial setting, there was, I think the state had made the concession that in fact the statement, the translation was not timely filed. Is that correct?
For this trial setting, that is correct, Your Honor.
Okay. So, and the defense's request is that that statement be excluded, correct, Ms. Butterworth, Mr. Carmona?
Yes, Your Honor.
Okay. And so for purposes of our trial setting, then that will be excluded. So sustain the objection by the defense. Now, just because now we have a new motion for continuance, the new motion for continuance included an element, I guess the re-indictment, the fact that the case was now and is now re-indicted. Mr. Cox or Mr. Ferguson, what the state is requesting additional time to determine now under the capital murder charge to whether they're going to seek the death penalty. And so has there been any decision made as of today?
Not as of today, Your Honor. I believe that this is a decision that is weighty. I think justice absolutely supports us seeking the death penalty. Of course, the death penalty is, well, as the court knows, it's not an easy decision to make. We hate to make it hasty, and we are asking for at least 30 days in order to look at it and decide for Ms. Rosales to look at it.
Before I ask the defense for a response on that, I just wanted to get an update from the state. I also want to ask the state if anything has changed with respect to the additional items that I believe were on the first motion for continuance. So we still have, go ahead, Mr. Cox.
I have not received any indication that I am not due for jury duty on December 3rd, so that has not changed.
I didn't want to single you out, Mr. Cox, but it was one of them. But we also
Yes.
had, okay, perfect. So then we have still the issue with the evidence testing. And then
Yes.
there's been no update with respect to the 3 witnesses, correct?
No, Your Honor.
Okay, so I think now we have everything with respect to the motion for continuance, Mr. Carmona or Ms. Butterworth?
Judge, I'll be handling the discussion of our objection to the new amended motion for continuance. And I'd like to begin by just putting a little bit more procedural history on the record. Just to make sure that I know the court is aware, but just to make sure the record is clean as far as how this case has progressed. The defendant, our client, was arrested on February 28th of 2021 and has been incarcerated in jail since the date of that arrest. On March 5th of 2021, we had a bond hearing at the jail magistrate where the state was opposed to a reduction of our bond and argued at that hearing that the defendant was not entitled to self-defense since our client had been able to take the knife out of the victim's hand and therefore had disarmed him. So the bond request was denied and he continued to be held in the county jail. On June 16th of this year, all parties were given notice that the case was set for a jury trial on 11/5, on November 5th. And as Mr. Cox had conceded at our hearing on Tuesday, he was aware that the defendant was asserting his right to trial. Mr. Cox also let the court know that we have never even engaged in any kind of negotiations and that he was aware that from the get-go, we've maintained self-defense and that we were demanding our jury trial. So this isn't a case where there were some negotiations back and forth and we were close. That's not the case at all. We've never even begun negotiations. And from the very beginning, we have asked for our jury trial and let everyone know, the court and the state, that we wanted to go to trial. At our hearing on October 5th, the court reset our original jury trial setting that was set on November 5th to December 2nd, giving the state really another month to prepare for jury trial to make sure that we were accommodated with jurors. And I think that that was kind of an administrative decision to make sure that we had enough jurors to go forward on the jury trial setting. As of date, I just want to make sure I also put on the record, as of date, under obviously the old cause number, since the new cause number was assigned today, there have been no standard pretrial motions that are customarily filed by the state of Texas in preparation for trial, such as a witness list, a notice of extraneous, a notice of experts, etc. None of those have been filed by the state of Texas from the time that this case was set for trial up until today, and there has not been a subpoena issued by the state of Texas in preparation for our jury trial. On Tuesday, the state came before the court and asked for a continuance based on 3 reasons. Number one, that the newly designated first chair, Mr. Curtis Cox, who had not been present for all of the voluminous discovery hearings that we had litigated before, that the first reason was that he had jury duty after the day that we were supposed to proceed to trial. The second reason was that they had not received any items back from DPS that had been submitted for DNA testing. And again, I know Mr. Cox wasn't there for those original discovery hearings, but the court is absolutely certain and clear that the delay of those results are 100% at the hand of the DA's office, that they had never been submitted to DPS until it was discovered sometime in October. And they cite that for a reason to continue the case while our client sits in jail. The third reason was originally on Tuesday, when we litigated the motion to continue, was that there were 3 witnesses that the state were arguing were necessary for them to go forward in the trial. Even though there had been no subpoenas issued for those 3 witnesses. And on Tuesday, it was apparent that Mr. Cox, in arguing the motion, wasn't even aware that 2 of those 3 listed witnesses had provided written statements.
Hold on, Ms. Butterworth, 1 second. Ms. Garza, is everything okay over there? I'm seeing the annex light up a little bit while she's talking. Is there any issue with the interpretation at this point? Okay. All right. All righty. Thank you. Go ahead, Butterworth.
Thank you, Judge. Then yesterday, November 18th, after we were waiting for the court to rule on the outstanding motions, we get notice after 4 p.m. that Mr. Cox has filed an amended motion for continuance, adding a 4th reason to that original motion for continuance, that he had taken the case to the grand jury on the 17th and obtained an indictment for capital murder. And now that reason, the state of Texas is adding that 4th reason, that their decision to re-indict so late in the game, now they're asking for more time, even though they had that opportunity during all of the months that our client has been sitting in jail waiting for trial. But on November 17th, they chose to re-indict. And now they're asking for more time to determine whether or not to seek the death penalty against our client. This is the same state of Texas that on Tuesday, 72 hours ago, offered to release our client to the streets on a full PR bond So now they want more time to seek a decision on whether to give us notice that they're going to attempt to seek the death penalty. When the state of Texas judge decides to seek the death penalty and that decision has been made, they then must prove beyond a reasonable doubt to a jury that the defendant is so dangerous that life in prison will not assure the protection of our society and that he must be killed. Specifically, Article 3701 of the Texas Code of Criminal Procedure calls for the state of Texas to prove beyond a reasonable doubt with sufficient and competent evidence that there is a probability that the defendant continue to commit criminal acts of violence that would constitute a continuing threat to society. That will be their burden. I'm not sure, I don't know that any of the attorneys on the screen have tried a death penalty case before, but that will be their burden to a jury to prove to them beyond a reasonable doubt that life in prison is not sufficient for the safety of our community and that he must be killed in order to protect society from the future danger that they would be alleging that he is. That is the first prong that they would need to prove going forward on a death penalty case to jurors of our community. So it should take approximately -5 seconds for the state of Texas to make this decision that they're asking for additional time to make, because less than 72 hours ago, Mr. Cox offered this defendant, our client, a full PR bond. Your Honor, I believe that the enormous power that the state of Texas has right now isn't being respected or honored, where a defendant in this criminal justice system can be held in jail with so little consideration by the state of Texas that zero preparation was done on his case as he sits waiting for his jury trial in his cell. The state has shown even less respect for the power they possess, that during a last-ditch effort to buy more time after they were exposed for not being prepared for the current jury trial setting, without any process or procedure in place, a rogue prosecutor can unilaterally threaten the death penalty during a hearing that took place on Tuesday, basically attempting, threatening to kill this man in the middle of a hearing after moments of offering him a PR bond, because the defendant is asking to go to trial, is asking for his facts to be heard by the community, by a jury, which is exactly how the system was designed to work. I will remind the court, Judge, as the court is deciding whether or not to give the state of Texas this continuation because they're not prepared, and that is why they're asking for it. I will remind the court how exactly this went down on Tuesday. We're arguing the motion to continue. Mr. Cox explains to the court that he is intending, right before the final hearings motions, to take the case back to a grand jury to re-indict on capital murder. And Mr. Carmona responds, that's fine, re-indict on capital murder. We're ready. We're ready and we want to go to trial, and we will waive our 10 days notice. And then Mr. Cox replies, I do not think you can do that while we consider whether to seek the death penalty. However, I will seek the death penalty if that's what becomes necessary. Your Honor, we're asking to go to trial. We're asking the court to deny the motion for continuance. I believe that I have hopefully made the record very clear that the state of Texas has had plenty of time to prepare for this jury trial, plenty of notice, and that this matter finally go in front of a jury so that the facts can be heard and our client, who has been in custody, can finally have a resolution while we've been maintaining the entire time that he was entitled to self-defense. We're asking that the motion for continuance be denied, Judge.
Alrighty, Mr. Ferguson or Mr. Cox, who's going to take it? Anyone else? Do you all have a response?
Your Honor, this case was not being handled by Mr. Cox or myself. It was being handled by a couple of other prosecutors who assured us that, never brought it to our attention or to anybody above us, any attention that this case was not being prepared. But that's completely beside the point. When it came to our attention what the facts of this case was, the immediate thought was, well, we should re-indict because this is a horrible crime. In fact, I have no doubt that we can bear the burden of proof and prove everything that is required to get the death penalty. I have, in fact, tried a death penalty case to verdict. So, that implication is absolutely not true. But I can assure the court that, yes, we can carry our burden. That is not my concern. This case, when it came to our attention of just how heinous it was, we immediately started looking at, well, we've got to take it back to the grand jury and get it re-indicted. It should never have been indicted as murder. It should have been indicted as capital murder, and it should have been brought to Ms. Rosales' attention immediately, the seriousness of this offense, so that it could be considered for the death penalty. At this point, we have done so, and that is a very strong consideration. And I believe what Mr. Cox was saying the other day was, frankly, because justice requires it, if we are forced to make a decision immediately, we will be forced to make the decision to seek the death penalty. We would like more time so that Ms. Rosales can look at it and that we can look at it and see if there's any justification not to seek the death penalty. That's what we are trying to look for. But frankly, if we're not given any time, we will be forced into that decision. And keep in mind that this case is less than a year old. This happened in February of this year. If the court looks at murder cases across the board in every court in El Paso County, I am not familiar with more than maybe 2 out of hundreds that have ever gone within the first year. It is very understandable that it takes a long time to get testing done, because the way the laboratories are so backlogged that they require very specific things to be submitted, and detectives don't know what to submit. They submit the wrong things, or they fail to submit anything. And then our office has to get with them and talk about it. Usually we have an evidence review where the defense gets to come and look at the evidence. And then the defense usually requests things to be sent off as well. And there's only a limited number of things that can be tested. So, I mean, this illusion that, oh my God, this has taken so long, this has not taken a lengthy time at all on a murder case. So I would absolutely object to that characterization that somehow this has been delayed for an exceedingly or an extraordinary amount of time on a murder case. Right? And I do believe that the state should have at least 30 days once we've indicted his capital murder to seriously consider whether or not to seek the death penalty.
Mr. Cox, do you have anything to add?
Frankly, Your Honor, the thing that strikes me, I've been involved in 2 death penalty cases in the course of my nearly 15 years as a prosecutor. The first of those was Felipe Devora. The second of those was Fidencio Valdez. I find it concerning that the defense in this case is more intent on trying to drive this case to trial than they are on attempting to provide any information which might mitigate against a decision to seek the death penalty. But that is apparently where we are. I am authorized to make that decision on behalf of Ms. Rosales if that is what is necessary. We are asking for time to give it a thorough consideration, not in terms of the heinous nature of the offense, which is abundantly clear, but in terms of whether, based upon the expense involved, the amount of time death penalty cases tend to drag on in appeal, and other such considerations, whether the best interests of this community will be served by choosing to seek the death penalty as opposed to not. However, this is the state of Texas. And the right of the prosecution under Texas law to seek the death penalty case in a capital murder charge is a right that is effectively inviolate. And so, if necessary, I will make that decision to preserve our right to seek that sanction in a case as heinous as the one described by the evidence in this case.
And Your Honor, if I may, Mr. Cox, are you done? I did not mean to cut you off.
No, I am. Thank you, sir.
Your Honor, I'm just going to briefly add to that, and as Ms. Butterworth so eloquently and pointedly put out our reasons for objection, but I want to say I agree. It is in the great state of Texas's discretion to analyze the reasoning behind seeking the death penalty and not seeking the death penalty. What was said on the record 72 hours ago, us as lawyers in this great state should not be offended by the words death penalty. What we should be offended are the words used after the death penalty. If it becomes necessary. That, Your Honor, is a threat. That is using the highest consequence in American jurisprudence as a threat, if not continuing this case and giving the state more time for not doing their job. They can sit here and add as many attorneys as they want. Mr. Ferguson is my friend. He's a colleague. He has always been a straight shooter with me. I saw Mr. Avila earlier, a fellow Cathedral graduate, a good friend of mine. They have passed this around. Mr. Ferguson says this was given to attorneys that didn't know what they were doing outside of Ms. Rosales' knowledge. Mr. Briggs and Mr. Hines from the very get-go were looking at this case. To say now that it's death penalty, if that becomes necessary, that's a threat. And every lawyer in this state, every judge in this state, every prosecutor in this state should be offended. Thank you.
All right.
Your Honor, if I may, that's not a threat. If it becomes necessary, the reference is if it becomes necessary for us to make the decision immediately without any further time to consider, then the immediate decision is to seek the death penalty, because failing to do so precludes seeking the death penalty, even though it is justified in this case.
Understood. Thank you. I don't think I need to hear any more. Unfortunately, Mr. Ferguson and I share, I respect each of you and the tremendous responsibilities you have, not just on this case, for all of the other work that you do. However, Mr. Ferguson, when you say that the fact that this case was handled by multiple attorneys, I'm not going to question whether they had the skill level or ability or if there was confusion, is exactly the point. The point is that if we were in this position, meaning on the eve of trial, and the state had been diligent about handling this case, then I could put that into context and give you a little more consideration on your request for continuance. The problem is that is not what has happened here. This case literally went nowhere within your office. It was treated like a hot potato, just kind of got bounced over here, bounced over there. Meanwhile, Mr. Gabaldon is sitting in jail. And now he is indicted on a capital murder charge, which of course I agree with you, is totally within your discretion. And that's the thing. That's the thing, that this is your case. And I'm not going to question how we got here, but we're here. And so with respect to the state's motion for continuance, that is denied. We are set for trial on December 2nd. The defense motion for speedy trial, which was also outstanding from Tuesday, is granted. The objections regarding the COVID procedures, I did review the additional information provided. Those are overruled. The protocol is in place for which we can select a jury on December 2nd, and we do have those two panels. What I will add to the proceedings today is a deadline by which I need to know from the state of Texas whether or not they are seeking the death penalty. We are going to set that for a hearing. I know we have a final hearing plea deadline on the 30th, but this is not a case I can set on the regular docket, which is very busy on Tuesday. So we're going to do it on November 29th at 11 a.m. I tell you that is that we will set that hearing. Logistically, I need to confirm with the jail that we can get Mr. Gabaldon here and things of that nature. So it is subject to change. However, the deadline will be for the state at 10 a.m. that morning. Whether we have the hearing right after that or if we have to do it in the afternoon, I will work that out with the jail. If you all have anything else that needs to be heard, we can take advantage of that setting. Hear anything that is filed before that date. But make sure that if you are filing something that requires a hearing on that date, that it is done with sufficient notice to the other side so we can get responses. I don't want to be spinning wheels. We will be 4 days out from trial. So you have something to file unless there's something else outstanding. Anyone? Nope. All right. I will see you on Monday, November 29th. Thank you very much.
We will make.
Thank you, Judge.
Thank you,
gentlemen. Thank you.
Thank you.
All right. All right.
Your
Thank
Honor,
you, Mr.
if I may very briefly, just a reminder to council that anything filed between now and then has to be sent to Judge Perez and my email, please, so we can make sure and it's reviewed prior.
Thank you. And if there's things happening, we're having, I will just say a sure way to do that is kind of if you all want to circulate with any motions, email chains work great. So if you need to send something via email, notify the court, if you just circulate it amongst all of us, that's really the best way to make sure that nothing falls through the cracks. I will tell you this, let me put this out there as well, because I want to make sure you all understand that I am not, I mentioned this maybe on another hearing, I am at the same time trying to keep track of health concerns regarding all of these trial dates. So just know, it seems all during COVID, every time we've had a restart, there has been a health issue that comes up. So just know that there are a lot of factors that go into the decision to proceed or not proceed to trial, but just know it's always possible in our COVID world.
And
So Monday.
Oh,
Go ahead.
I think there's some sort of interference, but is it going to be Mr. Cox and Mr. Ferguson trying this case? now that I see Mr. Ferguson on.
Well, of course, the problem is I have not been cleared by my doctors to participate in a trial or to do anything where there's more than 5 people in a room, at least until January. So
Well,
I'm
Mr.
afraid
Ferguson,
this precludes me
So-
from being able to.
Right,
try a
and
case.
those are things that I think logistically we all have to square away. So I understand your question, Mr. Carmona. We're coming back on the 29th. I know the DA's office will go back and figure out what they're doing. All right,
it's good.
And
Mr. Ferguson.
and I apologize to the court.
no worries.
Because I had the heart transplant in March. It does, it places certain limitations on me. I have to get medically cleared.
Mr. Ferguson, you don't need to apologize for that, please.
I'm
Please,
just glad
I
to see you
totally
doing well.
understand.
I'm
sorry?
glad to see you, Scott, really.
Thank you, Omar. I appreciate it. Good to see you too.
We'll see you all, God willing, on November 29th. Please stay well, everybody, and have a happy